Hey, folks, thank you so much for joining us this evening. My name is Pablo de Jesus, and I'm the Executive Director of Unitarian Universalists for Social Justice. And we're deeply pleased to have you this evening for what UUSJ and I and our Democracy Action team thinks is an important conversation. We're here to learn a little bit more about a particular case, but also about the general issue of challenging lifetime voting bans. So out of respect and in deference to our guest speakers and role players, I would ask us to do that typical UUSJ roll call and just in the chat, put in your name, your state, your preferred pronouns, perhaps a land acknowledgement, but give our speakers a sense of who is in the room with them so they, get a sense of the audience tonight. So please go ahead and do that. We'll get started in a minute or two as we let people filter in. I would also ask that folks, please keep your mics muted. Sorry, we don't have the webinar package, so we can't do it for you in a kind and gentle way. We've got to ask you to do it, and we don't want to mute everybody's mics because then we have to mute the speaker mics and the host mics. We don't want to do that. So please mind your mic, mind your camera. Know that we cherish our bodies and our spirits. And if you need to go take care of your body and your spirit, go do that and make a choice about whether or not you want to leave your video on. In the interim, I'm asking folks to please put into the chat their name, their state, perhaps pronouns, a land acknowledgement. This will help our speaker this evening and our chalice lighter this evening understand who is in the room with them. I'm so happy to see several of you. I haven't seen you in a while. Members of our Democracy Action team and others who have joined us on many of our calls. So thank you for joining us this evening. We're taking the first few minutes of this session to welcome each other, to welcome you into the Zoom salon. We're putting into the chat our names, our states, our congregation, if you want to mention that, our preferred pronouns, a land acknowledgement. And again, it's mostly to give our speakers a sense of who's in the room with them. I'm reminding everyone that you should control your own mic to the best of your ability. Please find your mute button. It's usually something at the bottom of your dialogue box for Zoom. It usually looks like a microphone. And please mute it because I don't want to have to do it for you. That means you will be silenced throughout the entire event. And if we get to a moment where there are good questions that you want to ask, you may want to do that. Well, now I want to take a moment to just share with you that we're going to be hearing from a speaker from the Brennan Center. But before we do that, we're going to hear from Pastor Kirk. So let me introduce folks as we get started. So our chalice lighting this evening is by Reverend Kirk Freeman. Pastor Kirk is a minister of the Davies Unitarian Universalist Congregation in Camp Springs, Maryland. I want everyone to know that Davies is a founding member of UUSJ. They were one of the churches that bravely and wisely decided to help form UUSJ and supported the idea of Unitarian Universalists having a loud and vibrant voice for public policy and social justice issues here in the capital region. I also want you to know that Kirk serves as a member of the leadership team of UU Allies for Racial Equity and the Chesapeake Bay area chapter of the Unitarian Universalist Ministers Association. So Reverend Kirk is somebody who's involved in the things that we as Unitarian Universalists want to do in this region, in our home geographic footprint of Washington, D.C. In his previous career, Pastor Kirk served as a congressional staffer and as a lobbyist, and he lives in Washington, D.C. And I will admit that I actually know Reverend Kirk before he was Reverend Kirk. I count Pastor Kirk as an ally in the struggle for justice and racial equity, and I think of him as a sincere and deep friend in the work for advocacy and witness. I'll just say clearly, Pastor Kirk is one of those people who understands the advocacy component of what UUSJ does and tries to do. So I'm always happy to have Pastor Kirk join us for one of our events. And with that, I would like to invite Pastor Kirk to light our chalice.
Thank you so much, Pablo. It is true, I was once a lobbyist, and Pablo and I knew each other at that time. We actually attended a Jubilee training together. And that was when one of the moments when I knew ministry was actually where I was supposed to be. So my name is Reverend Kirk Freeman. My pronouns are he and him. A quick visual description is that I'm a large white man in my early 40s with dark brown hair, brown eyes, and a red beard. And I'm wearing a black polo shirt and a dark gray sweater. And as Pablo shared, I started serving back in September. I began serving the Davies congregation in Camp Springs, Maryland, which is just to the southeast of DC in Prince George's County, Maryland, which is just outside of our Beltway here in DC. And Davies is a small but mighty congregation. We're celebrating our 70th birthday this year, and we're named after A. Powell Davies, who was the giant in the field of advocacy and Unitarianism, and then Unitarian Universalism here at All Souls. When I arrived at Davies, some of the elders told me that they looked forward to trying some new things, but there were two things they didn't want to change. And the first was our shared benediction, which is that for as long as anyone can remember, the congregation has sung hymn number 402, "From you I receive, to you I give," to close every single service. And the second non-negotiable thing is that every week during our service, we share an opening litany, which I thought I might share as our chalice lighting tonight. This litany was written by the congregation along with my predecessor and dear colleague, Reverend Norman Allen. And I'll share 5 statements. And when I complete the statement, I'll invite you to respond with the words, "We hold our history, we don't look away." I encourage you to remain muted for logistical purposes, but please know I will know you're repeating it along with me. We hold our hands and say, "We hold our history, we don't look away." We remember that the land where our beloved sanctuary stands is the ancestral and unceded land of the Piscataway people, who've journeyed among these hills and cared for this land for 800 years and more, and who remain an integral part of our community. We hold our history. We don't look away. We lift up the memory of the enslaved people who worked this land without choice or reward, and whose descendants are with us today. We hold our history. We don't look away. We remember all those who are central to the history of this land, but who have been marginalized in the telling of that history, and who are denied the gifts this nation has to offer. We hold our history. We don't look away. We remember that our nation is built upon systems of education, law, medicine, and finance that favor the descendants of the conquerors and put obstacles before the descendants of those they oppressed and enslaved. We hold our history. We don't look away. And even as we acknowledge these truths, we also remember that no person and no nation is defined by their worst actions. We remember that it is only we who can change the course of history. And we remember that the arc of the moral universe bends towards justice if we make it so. We hold our history. We don't look away. And so I light our chalice tonight, acknowledging that even as we hold our past, our values urge us and they call us to action in the present in order to build a better tomorrow. Let us keep faith with our values and let us keep faith with one another. Let us give and let us receive. And by this, we will build a more just, equitable world together. May it be so. And amen.
Thank you, Pastor. I just want to hold for a moment the words of that chalice lighting, sit with it. There's a lot of stuff embedded in there. And so much of tonight's conversation is going to be about the history of oppression and racial injustice and how it gets expressed through our carceral system. And so that is something that we hold. And I think that's serious business. So I want to take a moment. And thank you for joining me in that moment of reflection. I wanna underscore that for me, at least, and in my capacity as executive director of Unitarian Universalists for Social Justice, Patrick Berry's presentation and briefing to us tonight, it really matters for us as UUs because we are interested in root causes and systemic change to address root causes. And so in so many ways, the effort to address systemic injustice requires systemic change, and systemic change often starts with small acts of resistance. And in my view, this case is one of those small acts of resistance that can help catalyze a broader systemic change. We won't see that broader systemic change immediately, but this is an important step in bending the moral arc of the universe towards justice, and towards justice in this case. So with that in mind, please allow me to add Patrick to the spotlight with me and introduce him to you. So Patrick Berry is counsel in the Brennan Center's democracy program, focusing on restoring voting rights, promoting fair, diverse, and impartial courts. And these are all things that UUSJ cares about and has acted for and on for many years. And many Unitarian Universalists, many members of UUSJ are deep and sincere fans of the Brennan Center. We really like what they do. So we're tickled pink, frankly, that we finally have a Brennan Center speaker joining us. Now, during law school, Patrick was a law clerk at CREW, which is the Citizens for Responsibility and Ethics in Washington, D.C., and also for open primaries. And as many of you know, at UUSJ, we value CREW, who have presented to UUSJ on more than one occasion. So it's really nice to see that connection reemerge this evening. Patrick also received his BA from the University of Central Florida and his JD from the University of Pennsylvania Law School, where he participated in the legislative clinic and was the executive editor of the Journal of Law and Public Affairs. So Patrick has roots in one of the most important battleground states in the Union, and he went to law school in one of the states where Unitarian Universalists are most present and muscular through their work as a state action network. In fact, I think if memory serves, The State Action Network of Pennsylvania is one of the few that is a formal 501c4. So they get to play in a slightly different way than most state action networks do. So with that in mind, I'm going to leave the spotlight and leave the presentation and briefing to our new and deeply valued friend, Mr. Patrick Berry. Thank you, Patrick.
Thank you so much, Pablo. It's very kind of you. And hello, everybody. Thanks so much for having me with you this evening. Again, my name is Patrick Berry, and I'm a voting rights attorney at the Brennan Center for Justice. My pronouns are he, him, and I'm happy to be here this evening to speak with you all about Hopkins versus Watson, which is a very, very important case that's currently pending before the Fifth Circuit Court of Appeals regarding the constitutionality of Mississippi's lifetime voting ban for people convicted of certain felonies. But before I get into the specifics of that case, I'm going to start with some background about felony disenfranchisement more generally. If I could please get my slides up, Pablo.
Yes, on it.
Thank you. Okay, great. So let's get started. So across the country, there are an estimated 4.6 million people barred from voting because of a felony conviction. Most of these citizens are no longer incarcerated. They're living in the community like you and I, yet they're not allowed to vote. And because of bias in the criminal justice system, these voting bans disproportionately affect Black adults. Nationwide, 1 in 19 Black adults are disenfranchised because of a felony conviction, and in some states, the rate is much higher. Latino Americans are also disproportionately impacted. At least 506,000 Latino adults, or almost 2% of the voting eligible population, are disenfranchised because of a felony conviction. Next slide, please. So this discriminatory impact is no mistake. While criminal disenfranchisement laws can be traced all the way back to ancient Greece, and they existed in some parts of the United States before the Civil War, it wasn't until the expansion of suffrage to Black men that these laws became the major barrier to voting that they are today. After the Civil War, many states enacted a range of criminal laws that were designed to target Black citizens, while also adopting laws revoking the right to vote from anyone convicted of a felony. These laws, which were enacted at the very same time as poll taxes and literacy tests and other Jim Crow era laws, weren't just limited to the South. States across the country, including California, Illinois, Nebraska, and New York, also adopted broad felony disenfranchisement laws at this time. Next slide, please. As you can see from this map, felony disenfranchisement laws vary widely across the country. Maine, Vermont, and Washington, D.C., which are in light blue on the map, never take the right to vote away, meaning people in prison can vote. Virginia, the one dark red state on the map, permanently disenfranchises everyone convicted of a felony unless they receive an individual discretionary pardon from the governor. The remaining 47 states fall somewhere in between, forming a very confusing patchwork. The darker blue states that you can see on the map restore voting rights upon release from prison, meaning everyone who's living in the community can vote, including people on probation and parole. The states in orange restore voting rights upon completion of all terms of sentence, including probation and parole. the one state in yellow, Louisiana, restores voting rights either when a person completes their sentence, including probation and parole, or 5 years after they've been released from prison, whichever is sooner. And the red states that you can see on the map are states that permanently disenfranchise at least some people convicted of crimes, unless the government improves individual rights restoration. Next slide, please. So felony disenfranchisement laws are incredibly, incredibly confusing. And this isn't just for people with past convictions, it's also for government officials. So to give you an example, it's possible for a person with a felony conviction to be eligible to vote in one state, but no longer eligible should they move to another state. Even within a single state, the rules can be confusing, contingent on things like the date and the date and type of crime a person was charged with. Making matters worse, election officials receive little to no training on these laws, and there is little to no coordination between election offices and the criminal system. And so these factors taken together often result in the mass dissemination of inaccurate and misleading information, which in turn results in widespread confusion. And this confusion, unfortunately, has real consequences. Every year, untold numbers of eligible voters are unsure about their eligibility, so they refrain from voting out of concern that they'll be prosecuted. And compounding this fear, a number of states, including Florida, Tennessee, and Texas, have begun prosecuting people with past convictions for mistakenly registering to vote while ineligible. There's also evidence that felony disenfranchisement can have a spillover effect, harming families and entire communities. Studies have shown that the disenfranchisement of the head of a household can discourage his or her entire family from civic participation. And this makes sense when one thinks about how many people first experience voting and political engagement, their parents. There's also research suggesting that felony disenfranchisement may affect voter turnout in neighborhoods with high incarceration rates, and this is even among people who are eligible to vote. And so consequently, all residents of these communities, not just those with past convictions, become less influential than residents of more affluent communities from which fewer people are sent to prison. Next slide, please. Can you go back one slide? It's, there we go, legal challenges. So despite this racist history and the harmful impact of felony disenfranchisement laws, efforts to challenge them in court have largely been unsuccessful because of a United States Supreme Court decision called Richardson versus Ramirez. And in that case, the Supreme Court held that states are granted an affirmative sanction by Section 2 of the 14th Amendment to disenfranchise people convicted of crimes even after they've completed their sentences. So to put that differently is the Supreme Court in that case said that it's constitutional for a state to disenfranchise people convicted of crimes. That said, the court's decision in Richardson was not without bounds. Nearly a decade later, in a case called Hunter versus Underwood, the Supreme Court held that felony disenfranchisement laws that are enacted with discriminatory intent violate the 14th Amendment. After Hunter, advocates, including the Brennan Center, challenged a number of states' policies on the grounds that they were enacted with discriminatory intent, but lower federal courts have severely limited the application of the Supreme Court's decision in Hunter. Several circuit courts, for example, have held that although a state's felony disenfranchisement law was originally motivated by discriminatory intent, subsequent amendments to the law removed the discriminatory taint associated with the original version. Felony disenfranchisement laws have also been challenged under the First, Eighth, and 24th Amendments, but these efforts have largely been unsuccessful because courts, again, following Richardson versus Ramirez, have been skeptical of arguments that a state's felony disenfranchisement law can be lawful under one provision of the Constitution, namely the 14th Amendment, which is what the Supreme Court said in Richardson versus Ramirez, but not another provision of the Constitution, like the First Amendment or the 24th Amendment. Advocates have also brought challenges to felony disenfranchisement laws under Section 2 of the Voting Rights Act, which prohibits states from denying anyone the right to vote based on race. But some circuit courts have held that Section 2 doesn't apply to felony disenfranchisement laws at all, while others have held that absent evidence of intentional racial discrimination, which is very difficult to provide, felony disenfranchisement laws don't violate Section 2. And advocates have also tried to challenge felony disenfranchisement laws under state constitutions, but those challenges have fared similarly. Last year, for example, North Carolina's and Minnesota's state high courts both rejected challenges to those states' bans under their state constitutions. Next slide, please. So fortunately, advocates have had much more success changing their state's felony disenfranchisement laws outside the courtroom. In just the last 6 years, 14 states and Washington, D.C. have taken action to restore voting rights to more people with past convictions. 10 of these states, along with Washington, D.C., did so through legislation. And while most of the legislatures responsible for passing these laws had Democratic majorities, Louisiana bill restoring voting rights passed out of a legislature that was dominated by Republicans in 2018. In 2 more states, Florida and California, voters themselves restored voting rights to their fellow citizens through ballot measures. And the Florida measure passed with almost 65% of the vote, receiving 1 million more votes than any statewide candidate for office that was on the ballot, a clear demonstration of bipartisan support. And in the last 2 states, Iowa and Kentucky, state governors took executive action to expand the franchise. Iowa's governor is a Republican and Kentucky's governor is a Democrat. This progress, unfortunately, has not been without some setbacks. In 2019, shortly after Florida voters approved the ballot measure that I mentioned, state lawmakers enacted a law that severely limited the reach of that measure by requiring people with past convictions to fully pay off all of their court debts before their voting rights can be restored. And the legislature enacted that requirement despite knowing that no one in the state of Florida, including the state itself, has a database for tracking how much people were ordered to pay or how much people have paid. And so that requirement has introduced a lot of confusion and resulted in the disenfranchisement of hundreds of thousands of people simply because they can't afford to pay off their court debts. And last year, Virginia's governor ended his predecessor's policy of automatically restoring voting rights to people with felony convictions, making Virginia the only state in the country that categorically and permanently bars anyone convicted of any type of felony from voting unless they apply for and have their voting rights restored by the governor. And so there are also some states that have remained at a standstill despite all this progress, which brings me to Mississippi. Next slide, please. So Mississippi has one of the nation's harshest felony disenfranchisement systems. As I mentioned earlier, nearly all states take away the right to vote for some period of time after a felony conviction, but the vast majority restore voting rights either when someone's released from prison or after they complete their sentence, including probation and parole. In Mississippi, however, people convicted of one of 23 felonies, including stealing $250 worth of timber and writing a bad check for $100, are banned from voting for life. Mississippi technically allows people to regain their voting rights if they receive a pardon from the governor, or if they can persuade lawmakers to introduce and pass individual bills just for them with 2/3 approval, but such acts are vanishingly rare. No governor has granted pardons since 2012, and lawmakers have passed few bills to restore voting rights in recent years. And last year, they actually passed none. And any bill that's passed by the legislature to restore an individual's voting rights would also have to be approved by the governor. Next slide, please. Given how difficult it is, one slide back. There we go. So given how difficult it is for people in Mississippi to regain their voting rights, it should come as no surprise that Mississippi disenfranchises a higher percentage of its residents than any other state in the country. According to the Sentencing Project, roughly 240,000 Mississippians were barred from voting as of the 2022 midterms. That's nearly 11% of the state's voting age population. Mississippi also has the second highest percentage of disenfranchised Black residents of any state in the nation. And though Black people represent 38% of Mississippi's population, almost 16% of Black adults in the state are permanently banned from voting. Next slide, please. Like other felony disenfranchisement laws in the United States, there's a deep and troubling history of racism driving Mississippi's law. Mississippi first adopted its lifetime voting ban as part of the state's 1890 Constitution in reaction to the expansion of Black suffrage and other political rights during Reconstruction. White lawmakers, when they were crafting this provision, chose 9 crimes that they believed Black men were more likely to commit. And those crimes were bribery, burglary, theft, arson, obtaining money or goods under false pretense, perjury, forgery, embezzlement, and bigamy. Since then, the list of crimes has been amended twice, once in 1950 to remove burglary, and then again in 1968 to add murder and rape, crimes that white lawmakers historically excluded because they were not considered to be crimes a Black person was prone to commit. And over the years, Mississippi's Attorney General has also deemed certain crimes to be permanently disqualifying, such as timber larceny, bringing the total number to 23. Next slide, please. So in 2018, the Southern Poverty Law Center and the law firm Simpson, Thacher, and Bartlett filed a class action lawsuit on behalf of Mississippians with felony convictions who are permanently barred from voting, even though they've completed the terms of their sentences. The lawsuit, which was filed against Mississippi's Secretary of State, alleged that Mississippi's lifetime voting ban violates the Eighth Amendment's prohibition against cruel and unusual punishment. The lawsuit also challenged Mississippi's ban and the legislative process for restoring voting rights on other grounds. But for purposes of this evening's presentation, I'm going to just focus on the plaintiff's Eighth Amendment claim. On August 4th, 2023, a 3-judge panel of the Fifth Circuit held Mississippi's lifetime voting ban violates the Eighth Amendment's prohibition against cruel and unusual punishment. In striking down Mississippi's ban as unconstitutional, the panel determined that there is a national consensus against lifetime disenfranchisement, as 35 states and Washington, D.C. do not have such a policy. The panel also observed that within the last 50 years, the number of states with any form of a lifetime ban has decreased from 27 to 16. And this movement away from lifetime disenfranchisement, the panel said, demonstrated that society has moved away from that form of punishment. Next, the panel determined that lifetime disenfranchisement is a disproportionate punishment for people who have completed their sentences. In so holding, the panel reasoned that because the right to vote is a fundamental political right that's preservative of all rights, permanent denial of the franchise is an exceptionally severe penalty, especially as applied to people whom the criminal justice system has already deemed to have completed all terms of their sentence. The panel also reasoned that lifetime disenfranchisement serves no legitimate penological purpose because severing people from the body politic forever ensures that they'll never be fully rehabilitated, continues to punish them beyond the term their culpability requires, and serves no protective function to society. Therefore, the panel concluded that Mississippi's lifetime ban is cruel and unusual. So the panel's ruling was groundbreaking and significant for at least four reasons. First, as I mentioned, Mississippi is the worst state in the country when it comes to felony disenfranchisement. Nearly 11% of the state's voting age population can't vote, and Black people are almost 3 times more likely than white people to be disenfranchised. Second, the panel's ruling was a very rare victory for plaintiffs challenging a felony disenfranchisement law in court. In fact, the panel's ruling was issued shortly after the United States Supreme Court declined to hear the appeal of a separate case challenging the same provision of Mississippi's Constitution under the 14th Amendment, in which the Fifth Circuit held that Mississippi's policy had been cleansed of its discriminatory intent because Mississippi had amended the list of disenfranchising crimes a number of times. The panel's ruling is also significant because it was the first time that a court held a state's felony disenfranchisement law violated the Eighth Amendment. And finally, the panel's ruling was significant because it was based in large part on the trend that I mentioned earlier of states changing their laws to allow more people with past convictions to vote. And that's a trend that was achieved by advocates outside of the courtroom. Next slide, please. So shortly after the panel issued its groundbreaking decision, the state of Mississippi asked the entire Fifth Circuit, which is around 20 judges, to rehear the case. The full Fifth Circuit agreed to do so, and its decision to rehear the case lifted the panel's decision, putting Mississippi's lifetime voting ban back into place. After the full Fifth Circuit agreed to rehear the case, Mississippi and the plaintiffs challenging Mississippi's law were ordered to file briefs with the court, laying out why they agreed with or disagreed with the panel's decision. Individuals and groups who aren't directly involved in the case were also permitted to weigh in on how the Fifth Circuit should rule by filing what's called an amicus or a friend of the court brief. And one way to think of amicus briefs is really formal letters of support for one party to a lawsuit. And only one amicus brief was filed in support of the state of Mississippi, and 7 briefs were filed in support of the plaintiffs challenging Mississippi's law. And so one of those 7 briefs was a brief that was filed by the Brennan Center and the law firm Latham and Watkins on behalf of 30 faith-based groups and religious leaders, including UUSJ. And you can see on the right part of the slide, the arguments that are made in that brief. Other briefs that were filed in support of the plaintiffs were from criminal justice reform groups like the Cato Institute and the Due Process Institute, voting and civil rights groups, law enforcement groups and leaders, attorney generals for Washington, D.C. and 21 states, as well as Rutgers Law School's International Human Rights Clinic. The full Fifth Circuit heard oral argument last month on January 23rd. And following the argument, it's not clear when the Fifth Circuit will issue its ruling. There aren't any requirements for how timely the court has to issue its decision. It could release it tomorrow. It could release it next month or next year or even later than that. I'm aware of cases where the court didn't issue its decision for 2 or 3 years. And so it's hard to know for sure when the Fifth Circuit is going to rule in this case. But whatever the Fifth Circuit decides, that decision will very likely be appealed to the United States Supreme Court. And if that happens, the justices don't have to accept the case. They can decline to hear it. But if they do take the case, it will be the first time in decades that the Supreme Court considers a case related to a state's felony disenfranchisement law. And while we wait for the Fifth Circuit and possibly the United States Supreme Court to rule in this case, Mississippi's ban will unfortunately remain on the books and continue to prevent tens and thousands of Mississippians who have completed their sentences from voting. Next slide, please. So how could you fight back against lifetime bans like Mississippi's, which, as a reminder, exists in 10 other states, namely Alabama, Arizona, Delaware, Florida, Iowa, Kentucky, Nebraska, Tennessee, Virginia, and Wyoming. The most comprehensive way to address these bans is through federal legislation, and Congress is currently considering a federal bill called the Democracy Restoration Act, which would allow all Americans who aren't in prison to vote in federal elections, regardless of whether they have a criminal record that would make them ineligible to vote in state elections. So if Congress were to pass this bill, all of the people in Mississippi who are living in the community would be allowed to vote in federal elections, even though they wouldn't be permitted to vote in state elections. The other way to get rid of these bans is by supporting state level efforts to reform them, which, depending on the state, can either be accomplished through legislation or it has to be accomplished through a constitutional amendment. And so none of these options are easy, but the progress that we've seen in recent years to allow more people with past convictions to vote, and the fact that that progress has been the result of bipartisan support, gives me and my colleagues at the Brennan Center hope that more progress is ahead, regardless of how the Fifth Circuit ultimately rules. And with that, I'm happy to turn things over, and I'm looking forward to questions.
Thank you so much, Patrick. So let's see, stop sharing my screen. Sorry about that hair trigger mouse of mine. I apologize. And then I'm gonna ask folks to put into the chat their questions, or if you feel like you have a cogent, concise question for Patrick, then to raise your electronic hand and I will recognize you. But I do want to call on Karen Mills, who's associated with, she's the Democratic strategist for the Minnesota UU State Action Network. And I'm going to ask her, because I know from talking with Karen and working with Karen in one way or another, that in her state, they put a lot of work into voter disenfranchisement issues. So I'm assuming that Karen has a great question. So Karen, if you could, there you are. Now that I put you on the spot, I'll also add you to the spotlight so you can ask your question.
Well, thank you so much, Pablo, and thank you, Mr. Berry, for the presentation. Just appalling and fascinating and so informative. And yeah, where I live in Minnesota, in 2023, we were a state together with New Mexico, who also last year just moved ourselves from the orange to the blue, which means we got rid of a rule where if someone had a felony conviction in our state, they were allowed to vote again after they had finished all of their outside sentence. But after they had been released on parole or probation or community relief, if they had served the entire sentence, which can take years or decades, then they could vote again. But we passed the new law to make us a better state. So now when people are actually out of prison after a felony conviction and they're working, they're on parole, on probation, on community release, and paying taxes and living with families and being part of our communities again on the outside, they are also allowed to vote. So UUs were pretty involved in that here. It restored the vote to 55,000 Minnesotans who will be able to vote in August and November, who would not have been able to vote before. And here in Minnesota, there were 75 organizations that came together as a coalition, including faith-based labor unions, direct service, civic engagement, and public safety associations. I think, looking at the map that you shared, really my question coming out of this is, are there, is there sort of some opportunities out there, some particular states, some places where people can dive in? How would you prioritize maybe that, Unitarians who have some energy around this issue and who know from the fact that we did it with just one vote majority and some bipartisan involvement, right? Very, very controversial, but we did it. How can we share the love and let other people also, sort of move this forward?
Yeah, so that's a great question, and thank you, Karen. And I will say that, so at the Brennan Center, we advocate at the state level as well to restore voting rights. And often when we're doing that work in coalition, the faith community is a part, and the faith community is just a major force in parts of those efforts. And me and my colleagues were very thrilled when we saw that Minnesota changed its laws. And we were very happy to change the color. We're happy to change the color on our map as long as it's going to blue and not going to red or dark red in the case of Virginia. And so in terms of states where there's a lot of potential, unfortunately, as I mentioned, where we've seen the most movement, it's been states with Democratic control. That said, this is a bipartisan issue. And so looking at the states with permanent bans, I would say that Virginia certainly is a place where there's a lot of energy around this issue. People were understandably very upset when Governor Northam stopped using his clemency power to restore voting rights. That's actually something that a number of governors before him, both Republican and Democrat, did. And so there's a lot of energy in Virginia around getting a constitutional amendment to go before voters. And I would also say that Delaware is a state that is in the Northeast and is surrounded on our map with blue and light blue. And so, bills have been introduced in Delaware that would allow for a constitutional amendment to get rid of the state's lifetime voting ban. So those are two states that immediately come to mind. Iowa's also another state. Governor Reynolds is a major proponent for restoring voting rights. I mentioned that she is currently using her executive authority as a governor to automatically restore voting rights. If she wasn't doing that, Iowa would have the same policy as Virginia. And so it would be much more difficult for people to have their rights restored. And so certainly Iowa, and I think Kentucky as well. But I would also just say all of these states are places where people should be making this effort.
Thank you, Patrick. I'm going to ask two quick questions from the chat, and then I'm going to privilege Victoria since she has her electronic hand raised. But thank you, Karen. We deeply appreciate the work you've done in Minnesota. So one of the questions from the chat is, did you get to listen to the oral arguments, and do you have any sense of where things are headed?
Yes, so I did listen to the arguments. And I honestly don't have a sense of where things are headed, unfortunately. I think I may have said this during my presentation, but the Fifth Circuit is one of the most conservative courts that we have in the country. that said, a lot of the argument was about the fact that, yes, there are some states with permanent bans, but those permanent bans only apply to people convicted of very serious crimes like murder, or a felony sex offense. But in Mississippi, it's possible, for someone to be permanently disenfranchised because they pass a bad check for $100. And so a number of the judges on the court focused their questioning on that. And a lot of the debate was around, whether or not lifetime disenfranchisement is a punishment. The state took the position that it's not a punishment, it's a qualification for voting, like being 18 years old and being a citizen. And that's an argument that I think, is absurd. I think it's clear that taking the right to vote away from someone who's convicted of a crime is a punishment. But it's hard to say how the Fifth Circuit will rule in this case.
Thank you. Another quick question, maybe closer to home for you in particular, but what's your sense of what happened to the folks in Florida who voted believing their felony conviction no longer prohibited them from voting? And why Florida turn around?
Yeah, so it's very disappointing and upsetting what's happening in Florida right now. As I mentioned, voters in 2018 approved a constitutional amendment that actually brought an end to permanent disenfranchisement in Florida. It restored voting rights for most people who had completed the terms of their sentence, including probation and parole. The measure did have a carve out for people convicted of murder or a felony sex offense, but it was supposed to re-enfranchise 1.4 million people. And the legislature responded to that measure, also known as Amendment 4, by passing legislation to quote unquote implement it. And that legislation defined certain terms in Amendment 4 such that people with felony convictions can't register and vote unless they've paid off all their fines and fees. And I mentioned during my presentation some of the issues with that requirement. But over the last 2 or 3 years, dozens of people with felony convictions in Florida have been charged with registering or voting while ineligible. And these are very serious third-degree felonies. And these are all individuals who were either told by a government official that they were eligible, or they were told by a canvasser, or they received a voter information card in the mail, which made them think that they were eligible. And so Florida, unfortunately, is an example of how the confusion around eligibility after a felony conviction can manifest. And a number of those individuals who have been charged have taken plea deals with time served and no fines and fees. But 2 people who went to trial got split jury verdicts, and those cases are currently on appeal. And we actually filed amicus briefs in those cases. And I had a conversation with Pablo, not to put Pablo on the spot, but there's another case involving someone who got a split jury verdict in Florida that we're planning to file on behalf of the faith community.
Thank you so much, Patrick. Victoria, I'm going to add you to the spotlight and ask you to be brave and ask your question.
Hi, I am a senior in my undergraduate right now, and I'm actually writing my undergraduate thesis on felony disenfranchisement and like its history. And so I kind of wanted to ask, well, I think this case is really interesting, but like, have you, in your work as a voting rights lawyer, seen similarities or discrepancies in like language that the court has released or in the state constitutions, which is kind of what this case deals with in both ways? Yeah,
so the language that's used by states to disenfranchise people is pretty similar. So yeah, but like I mentioned, I mean, even states like Mississippi, where there's a very clear record of lawmakers doing this intentionally to disenfranchise Black people, courts have rejected challenges to those laws when the felony disenfranchisement provision at issue was amended after it was originally enacted. And what the courts say in those cases is, yes, the original version was tainted by racist intent, but it was the racism, was washed away when it was amended, because the lawmakers who amended it, or the voters who amended it, weren't the same ones who enacted the originally racist provision. But the state constitutional provisions regarding felony disenfranchisement are largely similar. Yes.
Thank you.
One other thing I would quickly add to that is
Yeah.
Virginia, Iowa, and Kentucky are the only 3 states in the country whose constitution requires people to be disenfranchised unless the governor restores voting rights. Other states, have some discretion on what the policy looks like, but Virginia, Iowa, and Kentucky are unique in that respect.
Thank you so much.
Thank you. And I think we're gonna try and shoot through 2 really quick questions from the chat. So, and then we'll close out a sacred space. So, Patrick, could you talk a little bit about what would be the political impact of federal restoration of the vote of all felons once out of prison? And without going out too far out on a plank here, or on a plank here, how fearful do you think the GOP is of these additional voters in our elections? How much of that is playing a role?
Sure. So the Democracy Restoration Act, it's my recollection that if it were approved by Congress, it would restore voting rights to 3.5 million people. And yes, one of the primary concerns when lawmakers are considering, legislation to restore voting rights is, what impact is this going to have on my chances of being reelected? And I will say that, it's not just Republicans who have those concerns. It's also, Democrats. New York is an example of a state that, not to put New York on the spot, where it's viewed as being very progressive when it comes to how it administers its elections. And New York changed its law back in 2021, to allow everyone who's not in prison to vote. But prior to that, New York had an especially confusing law, because people on parole couldn't vote, but people on probation could vote. And a lot of people don't know the difference between probation and parole. And so, lawmakers, both Democrat and Republican, do have concerns about, what implications this would have for purposes of, their being reelected. But we don't want this issue to be a partisan issue, because we know that when it goes to voters, it's popular with voters of all walks of life. And so we haven't really spent much time assessing what the political impact would be.
Well, thank you so much, Patrick. I've scanned through the chat, and I don't think we have any pending questions, because you did speak to how important the faith community can be in these fights. And with that, I want to pass the mic to Karen, because Karen has graciously agreed to close our sacred space. And then just to share with everybody on the call, as a custom here at UUSJ, what we do is we have what we do what we call a soft close. So everybody who has to go do something else is invited to go do that. But if you want to stay and hang around a little bit and process what you heard, I will hold some space and allow for the opportunity to do that. But our guests are invited to roll off if they need to. And if you don't like that sort of coffee hour vibe after services, then you don't have to hang around either. But with that, I'm going to look for Karen again and ask Karen to extinguish our chalice or simply close out our sacred space. Karen, are you ready?
Yeah.
Here we
So I
go.
went looking for some kind of reading or prayer or poem that could capture the pain and rage and hope of everything we've heard. I don't know that I found one. I don't know that that's possible. But after researching, what I came back to is a little poem that my mother, who was a fundamentalist, Unitarian Universalist, used to drum into us on a regular basis. And to me, I think it really sort of captures a child's version of transformative justice. It's a poem by Edwin Markham that's probably going to be familiar to a lot of y'all, at least you baby boomers out there. He drew a circle that shut me out. Heretic, rebel, a thing to flout. But love and I had the wit to win. We drew a circle and took him in. Amen. May it be so.
Thank you so much, Karen. Amen. May it be so. So thanks again to Mr. Patrick Berry. We deeply appreciate your willingness to appear for us and explain the case and explain the circumstance, explain that root cause of the systemic injustice that we see in Mississippi. And we invite Unitarian Universalists to get involved with our democracy action team. If you care about the health of our democracy, then one of the best things you can do is gather and share your power with others who are concerned about our democracy and figure out what the next step is, what we can do together in community. So again, thank you, Karen. Thank you, Kirk. Thank you, Patrick. We deeply appreciate you. This is the soft close of our event. For those of you who want to jawbone a little bit with me, I'm available to do that. Because I've learned over the years with UUSJ that folks want to process in community a little bit. Patrick, you don't have to hang around for that, but if you're going to find it interesting, feel free.
I'm happy to hang around for a little bit, but if folks would rather me leave, I'm totally fine with that also.
Sir, you are invited. You are warmly wanted and invited.
Thank
I just
you.
don't want to obligate you to extend your night. Well, because this is formally work for you, right? Like so, yeah.
It's one of the better parts of my job, I'd say. It's better than reading a bunch of boring cases. So happy to do it.
Thank you. So does anyone have something that's on their heart after hearing all this case history and the explanation of the case that they want to put into the public space? If so, please raise your electronic hand or begin to speak as the Spirit moves you.
Well, if I can jump in again, I took up too much space here, but so weird. Minnesota's getting all jazzed